please the court. My name is Mr. Chiang, and I appear with my learned junior Miss Bunting, and instructed by Mr. Passes for the plaintiff.
Thank you. And for the defendant.
May it please the court, Mr. Wong for the defendant. I appear alongside my learned junior, Ms. Driscoll, instructed by instructing solicitor, Mr. Holgate.
Thank you.
Proceedings concern the validity of Section 4 of the Protection from Protesters Act. The relevant section can be found at paragraph 7 of the evidence. It is our submission that this section offends the implied freedom of political communication and hence should be invalidated. To determine validity, regard must be had to the two questions in Lange and as modified in Coleman. It is our submission that both of these questions should be resolved in a manner that leads to invalidity. They are that first, the section effectively burdens freedom of communication, and the second is that it has an illegitimate purpose that is achieved in a manner that is not reasonably appropriate and adapted. Before I turn to the first of those submissions, if I may first define the scope of these proceedings. The implied freedom does not empower individuals with rights of free speech. Rather, it acts as a general restriction on the legislative power. As a result, to determine validity of the Act, regard must only be had to Section 4 itself. The plaintiff's individual circumstances are immaterial. If I may turn now to the first of the submissions of the plaintiff, that Section 4 of the Act effectively burdens freedom of political communication. In brief terms, Sections 7, 24, 64 and 128 outline the system of governance in Australia that has been defined as responsible and representative. Implied from this is a freedom of communication that has been protected in some instances from encroachment by the legislature. The crux of this part of the Lange test is whether that freedom of communication has been effectively burdened. The submission of the plaintiff that it does effectively burden it has essentially two parts. The first is that there is a pre-existing freedom of communication that Section 4 has burdened, and the second is that that communication went to political matters as opposed to mere commercial ones. Turning to the first of those issues, there was a pre-existing freedom that was burdened. Your Honours, at page 36 of our list of authorities, the case of Mulholland is extracted. Page 36, Your Honours. At paragraph 183, Justices Gummow and Hayne note that for there to be an effective burden on political communication, there must be a pre-existing common law freedom. In other words, it is necessary for the plaintiff to show that Section 4 prohibits conduct that, at common law, would have been permissible. To determine this, regard, of course, must be had to the section itself and a determination of what it prohibits. The offence in Section 4 has two elements, namely, an individual must be on business premises, and they must conduct a protest that prevents, obstructs, or hinders the carrying out of business activities. It is our submission that at common law, an individual is permitted to engage in that activity, and hence an effective burden is provided by the statute. In relation to
common law, there's an entitlement to hinder, prevent or obstruct.
Perhaps not so broadly, Your Honour.
Trade union officials would love to hear that.
It is our submission that the words prevent, obstruct and hinder capture a broad range of conduct that it prohibits. However, part of the conduct that is covered by Section 4 would be permissible at common law.
Like a community protest is distinct from a picket?
Yes, Your Honour. So in particular, acts that would enter into the land of tort, so for instance be assault, battery or nuisance, would not be permitted at common law, but there is a range of conduct prohibited by Section 4 that would not fall under the scope of those tortious actions. The preliminary matter, of course, is that an individual has to be on business premises. We submit that this would not be a trespass at common law because there is an implied license for individuals to enter on business premises.
On all business premises?
Not all business premises, Your Honour. Of course, premises that are closed or ones that are gated would not have that implied license.
But could one just walk into a factory?
No, Your Honour.
Or an office?
It would depend on each individual situation. It is our submission that at the very least, businesses that open their doors to the public and indeed require customers to enter into those premises do have that implied license of entry.
Because the Act is wider than that. I know in this case we're dealing with a cafe, but which is open to the public. But the Act covers all business premises, including factories and offices and premises of that sort.
Yes, Your Honour. However, this stage of the Lange test only considers whether there is an effective burden and does not consider the extent of that burden. So essentially our submission is one has an implied license to enter some business premises, and to the extent that that activity or that conduct is now prohibited by Section 4, there is an effective burden. Issues as to whether an individual may or may not be able to enter certain premises would go to the extent of that burden.
Do you say it's impossible to read down this piece of legislation, or at least read down this provision?
Yes, Your Honour. It is our submission that a provision can only be read down if there is a reasonable alternative construction that is open. And that was noted by this court at paragraph 42 of the case of Attorney General and the City of Appellant. We submit that the phrase, or rather the section as a whole, is unambiguous and clear in that it has a broad meaning, and as a result, reading it down is not permissible.
Or is it not possible to add the words unreasonably or appreciably or materially, whatever other qualifier, before the phrase prevents, hinders or obstructs the carrying out of a business activity?
Your Honour, that approach is acceptable if there are alternative constructions open. And that is indeed the path that this court took in the case of Monis, where the word offensive was qualified by the word significant. However, we submit that the words hinder, prevent and obstruct have a clear meaning in that they refer to a wide spectrum of conduct. And as a result, reading that phrase down to narrow that spectrum would go against the intent of that legislation. The crux of that submission is that those three words are alternatives, and that is noted by the use of the word or. But in ordinary usage, they also have distinct meanings. The word prevent has an absolute meaning in that it leads to the conclusion that a business is completely unable to carry out some portion of its activities. The word obstruct does not have that absolute meaning, but still refers to an impediment on business activities.
But in relation to your submission that they were engaged in lawful, otherwise lawful conduct, does that apply to throwing garbage on the floor? Would be impliedly revoked by that sort of action, wouldn't it?
Yes, Your Honour, but that revocation would be retrospective in that it would only operate after the business owner informs that entrant that the licence has been revoked and they must leave.
So if a person throws garbage on the floor of a cafe, the person is not a trespasser until told to leave.
Your Honour, we do accept that implied licences can have conditions attached to them. But it's our submission that these licences should be construed broadly to include entry to potential protesters. That is because it is difficult to distinguish between, on the one hand, legitimate complaints from customers and on the other hand, protesters. Because that distinction is difficult to draw, this court should imply the license broadly, so as to not unduly label those as trespassers. That submission is supported by the fact that businesses do not merely open their premises for the public to enter, but also actively encourage entry through means such as advertisements or sales. And that would be the distinction to instances such as with private property, such as one's own home, where a gate may be open, but there is no active encouragement by the landowner for others to enter.
But again, there's a license for people like mailmen and people like that to enter the premises without permission, isn't there?
Yes, Your Honour. And it's our submission that that implied license would accrue to those seeking to enter a business. And because of the nature of business activity, such as through advertising, that should be a broad license to permit entry to potential protesters.
Yes. You haven't considered, have you, the doctrine of trespass ab initio, under which when you go onto land with permission and then do something wrong of various types on the land, you become a trespasser from the moment you enter it?
Yes, Your Honour. However, that issue of trespass ab initio turns on the conditions on which one may enter that land. So it's our submission that prima facie, protesting is not a wrong that would make one a trespasser.
But throwing garbage on the floor might be.
Yes, Your Honour. We submit that in the present case, the plaintiff would be a tortfeasor, so potentially in negligence. However, in the general sense, Section 4 prohibits a wide range of conduct.
So you say ordinarily the implied license extends to entering into a business premises to prevent, hinder or obstruct the carrying out of a business activity?
Perhaps not so highly, Your Honour. It is our submission that that license should be construed, or implied rather, to include potential protesters. The distinction that we would draw to entering to prevent, obstruct or hinder business activities is that in many instances the nature of a business is to deal with such impairments. So for instance, a disgruntled customer seeking to vent legitimate grievances, a license would be implied in their favour, even though they would impede a business in carrying out its operations. It's our...
So you say an angry customer can come in to a McDonald's and make a complete fuss, a ruckus, and that would be within the implied license, so long as that customer had a legitimate complaint, for example, that his burger was bad.
Yes, Your Honour.
But
McDonald's. Indeed, Your Honour. But to then take it a step further, drawing a distinction between a legitimate complaint of that nature and a potential protester is an extremely difficult and arbitrary line to be drawn, and hence that license should be implied in favour of potential entrants who may wish to protest, so that they are not unduly labelled as trespassers.
The line's fairly clear here, isn't it? I don't think you're going to find too many members of Parliament carrying placards complaining about the food in the cafe.
Probably not, Your Honour. However, we would stress that the validity of Section 4 turns on the application of it in general, rather than the particular circumstances.
But why can we not read, I mean this comes back to the earlier point, then why can we not read down the provision to mean one is not entitled to prevent, hinder or obstruct business activities, or one is not unreasonably entitled to prevent, hinder or obstruct?
Because that would be adding a word into the section where there is no reasonable basis.
Or construing the words prevent, hinder or obstruct to mean?
Well, yes, Your Honour. We note that in Monis, the word significant was added into that phrase, in particular significantly offend. It may be useful to my argument to distinguish that case of Monis and why that word was added in. Essentially, our submission is that the words in monis, offend, menace, or harass, refer to three distinct types of conduct. The distinction is Section 4 refers to a spectrum of conduct with reference to impairment on business. So at the most extreme end of the scale is a prevention, a complete prevention of business activities. At a lower end of that spectrum is to obstruct business activities, and even further down on that spectrum would be to hinder. The fact that those three words operate on a single spectrum of conduct means that their clear intent is to cover a broad range of conduct. To add the word unreasonably would effectively narrow them to cover less conduct.
Monis, of course, is not really a very strong precedent, is it? Because it was an equally divided court.
Yes, Your Honour. However, all members of that court read down the word offensive to include the word significant. So essentially, to summarise the first issue in this submission, the plaintiff would submit that Section 4 covers a broad range of conduct and attempts to prohibit it. At common law, however, some section of that prohibited conduct would still be permissible. And that means that Section 4 provides an effective burden. Moreover, it is clear that protesting, as is used in the Act, is a form of communication. And that was noted in the case of Levy and Victoria. It is our submission, then, that for the Act to burden protesting essentially amounts to a burden of communication, which would answer the first question of the Lange test in the plaintiff's favour. If I may turn briefly to the second issue in this submission, and this is that the burden related to political communication rather than commercial matters. This distinction is important to draw because in the Australian Constitution there is no broad freedom of speech. Rather, the implied freedom is with reference to government or political matters. We submit that there is a close relationship between government acts on the one hand and protests on businesses, such that to speak of one is to essentially refer to the other. Most notably, the Commonwealth Government has legislative power with respect to corporations and commerce, and that's sections 51 subsection 1 and subsection 20 of the Constitution. That connection then means that a protest on business premises has a political reference. Moreover, the fact that government takes part in outsourcing regimes or corporatisation is a further link between acts of government and business operations. Therefore, we submit that Section 4 provides an effective burden on political communication, which satisfies the first Lange question. May it please the Court.
Thank you. Ms. Pansy. Sorry, I didn't get your name at the start.
Oh, Miss Bunting.
Bunting, sorry. Bunting. Thank you.
May it please the Court. Your Honours, as my learned senior indicated, we turn now to consideration of the second question before this Court. That is, whether Section 4 of the Protection from Protesters Act is reasonably appropriate and adapted to serve a legitimate end in a manner compatible with the maintenance of the constitutionally prescribed system of representative and responsible government. The second limb of the Lange test, as it was modified in Coleman and Power, will be considered in three parts, which we will address in turn. First, the discernment of the object and means of the legislation. Second, and naturally following, the assessment of the legitimacy of these legislative ends. And finally, a determination of whether the means of the legislation are reasonably appropriate and adapted to achieve their object. Your Honours, the plaintiff's case will only be made out should both questions in these proceedings be answered in the plaintiff's favour. In turning to the first element, being the determination of object. In order to ascertain the object of the legislation, ordinary principles of statutory construction are employed, revealing two concurrent purposes. The first is to protect private business rights. Now, both from the title of the Act, being protection from protesters, and from the elements of the section itself, the central concern is protection, further clarified in relation to specifically business or commercial interests. The offence will only come into operation where a protest hinders, prevents, or obstructs business activities on business premises. It is clear that protecting business rights is a central concern of this legislation and section. Your Honours, we note that our learned friends reached the same conclusion in their construction of the section, and we would not draw issue with this position. What we would further look into is the second construction.
Do you say it's business rights or business activities that's being protected?
Your Honour, not necessarily business rights, but it relates to the freedom of business owners and proprietors to preserve and continue their lawful economic exercises and commercial adventures without hindrance. Now, Your Honours, our friends has not contested that this is an object of the legislation or section in particular. We would move then to the second discernible object of this particular section, which our learned friends have remained silent on, which is that the object of this section is to regulate protesting. Now, mere hindrance or interference where one is not a protester will not bring the section into operation. Rather, it is directed specifically at the conduct of protesters only, particularly supported by reference to the title of the Act, which defines legislation in relation to protesters.
Now, you're entitled to look at the heading of the title of the entirety of the Act to interpret a provision.
Apologies, Your Honour, merely the short title that we are provided with?
Yes.
Your Honour, in the case that the present circumstances, we're restricted in that we only have access to the short title. And we do have authority for the fact that the short title may be used to ascertain policy, which would refer Your Honours to Northern Territory Planning Authority and Murray Meets, which may be found at page 39 of our list of authorities. Now, Your Honours, the issue of regulation of protesting has come before this court in relation to the freedom of political communication in two other instances, and that is in the case of Levy and in the case of Coleman. In Levy, the case concerned environmental protesters entering a duck shooting range, and the conduct prohibited was not protesting. The legislation was framed in reference to those entering the area during prohibited times without authority. Similarly, in Coleman, the legislation referred to persons who in a public place used any threatening, abusive or insulting words. Now, both of these cases indicate a distinctive and major difference from the present case. Their referential point is not the protester. Their concerns are with the prevention of physical injury or the prevention of violence in a public place. It is this legislation that actually isolates an integral component of the representative and responsible system of government, the ability to engage in public discourse and enter into public space with a voice, to give that voice to grievances, which is what protesting is. Moreover, Your Honours, the heavier penalties of this section, being framed as a fine not exceeding $10,000 or imprisonment for a term not exceeding 5 years, are onerous penalties, suggesting that the object of the Act is the elimination of such conduct. Your Honours, we turn then to the second element of this first inquiry, being the legitimacy of those legislative ends. Once again, we do not draw issue with our learned friend's submission that protecting business rights and activities is a legitimate end, but we would contend that the desire and object to regulate protesting is one that is incompatible with the system of representative and responsible government. Your Honours, legitimacy is defined as compatibility with the constitutionally prescribed system of representative and responsible government. Because the freedom of political communication is an indispensable incident of the constitutionally prescribed system, the object or end can only be compatible with the system if it is compatible with the freedom. Now, the cumulative effect of sections 7, 24 and 128, as my learned senior discussed, indicate a system where the people directly choose their representatives at periodic elections, and this requires the free access of the people to relevant information regarding the functioning of government in Australia. The attempt to burden protesting activities so as to expose protesters to harsh civil liability is inimical to the system of representative and responsible government in Australia, thus rendering the object of this Act illegitimate. Your Honours, both the object and means of this legislation must be compatible with responsible and representative government, and we would submit that in the present case, neither are.
Well, one would expect that a protester normally would get a bigger audience in a public place than on business premises. So, in a sense, restricting the place at which you can protest in that way may not be so severe a restriction.
Your Honour, however, the changing nature of the government, the relationship between government and business entities, mean that protesting on business corporations or on business premises may have an equally significant political effect than anything else made in a public space. For example, in Levy, the protesters' concern was environmental damage and caused by the destruction of endangered species. And the fact that they raised awareness of the destruction of endangered species, the protesters could influence the attitudes of voters towards matters over which the government has influence and their votes in federal elections, their power to regulate external affairs or environmental matters. Moreover, the increasing privatisation of businesses, if we may use the current case as illustrative of this, is that the plaintiff, Ms. Smith, was subjected to the injustices of having accountability passed on to a third party when the state government of Tasmania decided to outsource the responsibility for rubbish collection to a third party. To connect with politicians in this day and age where we are seeing the increasing privatisation of government departments is to make as much of a strong political statement as would any protest in a public space.
So it's what you're saying, if you run a parliamentary cafe, you're really asking for protests. It's such a good place to scream at your parliamentarians.
Yes, Your Honour, but no worse than a cafe in a law office. I think they would be open to liability all the time.
I think anyone who lived in Queensland in the previous era.
We're not to say that every commercial communication will necessarily have political content. We are saying that to establish an effective burden, we do not need to show that every protest will be of a political nature. The issue is that in the operation of this section, it covers protests that have a primarily political nature, and that is from this inextricable connection between commercial and political in the current climate.
So if a Labour candidate walks into BHP's steelworks and starts making speeches to the workers about why they should vote for him, is that something which is protectable?
Well, Your Honour, we would have to look firstly if they had a right to be in those premises in the first place. But turning to the instant issue in question, being the interference with the rights of political communication, we would submit that yes, that would be interfered with, and that would be an unreasonable burden upon the freedom to communicate in a political sense.
But do you tie your position to the right to be on the premises?
Yes, Your Honour, in a sense that we have to prove both limbs and therefore there must be a right at common law and for the first limb of this test to be rendered invalid, given that it will then, the necessary following element of that is that the section burdened the political communication so made when legitimately on those premises. Your Honours, if we may take you now to the third element of this second question, being whether the objects and its means are reasonably appropriate and adapted. Should Your Honours not be with us on the question of legitimacy, we would submit in the alternative that Section 4 is not reasonably and appropriately adapted to serve its end. Even if the law's objects are considered legitimate, its means to achieve that end must be a proportionate balance of the law's objectives and the mechanisms employed. On this, Your Honours, we have 4 points of argument. Firstly, that the law places a direct limitation upon protesting as opposed to an indirect interference. In such a case, general principles indicate that it is harder to justify such direct interference. Secondly, the expansiveness of the law may capture conduct that has only a minor impact on business operations, as was discussed by my learned senior in relation to the meaning of the term hinder. The section...
What was the meaning of the word hinder? I don't think Mr. Chiam got that far. He said prevent has an absolute meaning, whereby business activities are completely prevented or completely obstructed. The word obstruct means the impeding of business activities. What do you say hinder means?
In the shortest form, cause interference with. What we would say is that these
so
terms...
if someone spills a cup of coffee, I'm sorry, this is a painful analogy.
No,
if someone spills a cup of coffee in a political fashion, for example, one throws out all non-free trade coffee, then and makes some sort of spillage on the floor, that would be caught from your submission.
Yes, Your Honour. And that is the direct point that we are seeking to make, that this operation of this section is so broad that it could cover such seemingly arbitrary and ridiculous protests, such as throwing out a cup of coffee.
Or burning blue ties.
Watch out, Your Honour.
Blue tie.
To be fair, I'm not later.
Your Honour, we would also return to the fact that hinder is essentially unambiguous in its nature, and this is where questions of reading down or the principle of legality have no currency in this particular question. The fact that, as we said before, there are conjunctions between hinder, prevent or obstruct. They are meant in the alternative, and given their nature as different interferences on the spectrum, they are not analogous to the case of Monis, where menacing, harassing and offensiveness are different acts and emotions essentially experienced in a different way.
You seek to invalidate the Act both in relation to your client's words and in relation to her action of pouring the garbage on the floor.
Yes, Your Honour. There is no distinction in relation to political communication may be made through conduct as well as through speech.
As in legally, I
Yes, Your Honour. Your Honours, we would take one moment to address our learned friend's submission in relation to the margin of choice that should be accorded the legislature in achieving the ends.
I think I called it margin of appreciation in Mulholland.
Yes, Your Honour.
First instance. Mr. Bennett's urging and was scolded by Justice Kirby in the High Court.
I will consider myself scolded and speak on the margin of appreciation. Your Honour, our learned friends has cited Justice Hayden's and Justice McHugh's arguments in Coleman. However, despite the comments and the references they cited, Justice Kirby in Mulholland expressly rejected the notion of any deference to our margin of appreciation to the legislature. His Honour stated that...
I didn't have any choice because I was referring to High Court judges and I was a mere little federal court judge.
You're only in a position to make policy now.
Yes.
Basically, the doctrine of deference is a European doctrine.
Yes, Your Honour, and we would accept that it should be, or we would contend that it should be rejected in this circumstance, given that the point of our Longy test is to establish the fundamental principle that you cannot legislate in contravention of the Constitution, and the reasonably appropriate and adapted test is the litmus test of where the legislature has passed that legitimate point.
Can I ask this question? You say the words prevents, hinders or obstructs are effectively three words on the scale, where prevents is the worst, obstructs is somewhere in between, and hinders is down the bottom. Would it be possible for us to invalidate the words hinder or obstruct, but not the word prevent, such that the legislation operates only in situations where business activity is entirely prevented?
Your Honour, that would be a possible reading of it. However, we would suggest that that does not necessarily remove the contentious issue that is at the heart of this, and that is that it is protesters who are being affected.
There can also be a fine line between obstructing and preventing. If you put a car across a path, for example, the driveway, maybe only particularly skinny people might get into the particular classification of it
Yes,
being
sir.
prevented and everybody else is obstructed. Or everyone else is prevented and they're just obstructed, I should say.
Yes, right. So it can give rise to somewhat confusing and easily conflatable
Yes.
meanings, which is where the reason that we submit that total invalidity is to be preferred to any reading down or term severance in this matter. Your Honour, on a final point on that margin of appreciation, we assert that the law restricting the implied freedom cannot merely be seen as only be reasonably capable of being seen as appropriately adapted, because to be deferential to Parliament is to ignore that legitimate role that the judiciary plays in saying whether the legislature cannot legislate. And that is where we submit they have gone too far in these circumstances. Your Honours, in returning to our submissions in relation to how unreasonably appropriate and adapted this section is to achieving its goals, as a third point, we suggest that there were less intrusive and alternatives that could have been undertaken to achieve the legislative purpose. These are not conclusive in any way, Your Honours, but what they do indicate is that the law is not reasonably nor appropriately adapted. There could have been less severe penalties so as to mitigate the disproportionate punishment of offenders under the section. There could have been a distinction drawn between political or other forms of protesting. Once again, we would reiterate, these are not conclusive, but they do indicate the fundamental incompatibility of this section with achieving its aims in a legitimate manner. Finally, where a business owner may revoke the license of a protester and require them to leave the premises, failure to do so is conduct that may be captured by the revocation of the individual protester's licence. Thus, the Act unnecessarily protects businesses from conduct against which the common law already provides relief. Your Honours, if I may make one more point in relation to the failure of the legislation to be reasonably appropriate and adapted, and that is that in looking at the penalties supplied for this section, the fact that the conduct considered is so broad in nature, to expose an individual to possibly as a severe sentence as 5 years imprisonment or a $10,000 fine is far beyond any balancing exercise that this court could place to balancing those legitimate ends with those legitimate means. Your Honours, even though we recognise that the sentencing judge does have discretion in sentencing, the maximums do affect the ambit in which the judge operates and decides the sentencing case.
$10,000 is a lot of money in Tasmania. I'm serious.
I would say it's a lot of money in any state, Your Honour.
Especially in Tasmania.
I don't think all the Tasmanians were behind this law, Your Honour. We cannot all take it out on them.
Well, I was in a trade practices case in Tasmania where I thought the full court engaged in a bit of tinkering by increasing my penalties by 10%. Obviously they hadn't spent as much time down there as I had.
I have the impression that this law was enacted to deal with people protesting about wood chipping and gardens and
Yes,
things
sir.
like that.
That's GU double NS.
Sorry, Your Honour.
That's GU double NS guns.
It is.
Yes, guns, the timber people. The wood chip, the pulp mill. Probably all too young to remember that.
Yes, Your Honour, I think it's beyond my age range. Your Honours, in summation, we would suggest that the object that this section seeks to achieve and the means by which it does so are not reasonably appropriate nor adapted to the ends that they seek to achieve, nor is the entire process, the ends, the means, the mechanisms involved. None of them are compatible with the maintenance of the constitutionally prescribed system of representative and responsible government. In that vein, Your Honours, we would ask that you find Section 4 of this Act to be invalid in its entirety, with costs for the plaintiff. May it please the Court.
Wong, the defendant. I will address the first issue on whether there is an effective burden on the implied freedom of political communication brought about by Section 4 of the Protection from Protesters Act. To this end, I will make two submissions. Firstly, that for there to be an effective burden on political communication, a pre-existing right under general law must be burdened. Such a right is absent here. Secondly, even if a right is granted to enter the business premises, as granted by an implied license, the scope of the implied license does not extend to the activities prescribed under Section 4 of the Act. Addressing the first submission, to be an effective burden on political communication, there must be a pre-existing general law right. This was confirmed in a line of authority, including Mulholland and Australian Electoral Commission, and Levy and Victoria. In this case, the Protection from Protesters Act does not effectively burden the implied freedom, as Section 4 prescribes acts that would constitute trespass to land.
Isn't there a prima facie restriction on the right to protest? Isn't there, first of all, a right of peaceful protest? Courts have held, for example, in an industrial context, that there is a right for there to be a community protest on a particular issue, which would differentiate that issue from a picket.
Your Honour, to clarify, Justice McHugh at paragraph 107 of Mulholland said such a requirement of a pre-existing right prior to the invocation of the implied freedom arises due to the fact that the implied freedom does not connote a freedom to communicate, nor does it create rights. What we are considering here is whether there is a pre-existing general law right.
That's what my question is directed to you, as to whether is about. That is, whether there is a pre-existing right to engage in peaceful protest.
Your Honour, there is no pre-existing right to engage in peaceful protest on private premises. As such, private premises are governed by the law of trespass.
Well, I don't know whether authorities with you on that can't physically bring it to mind, but certainly the cases in industrial context in the federal court differentiate between picketing leading to conduct such as blocking premises and the like, and the rights of community people, including union officials and members, to gather outside premises and chant and scream and hold placards and bring other matters to the attention. You know, there's a fine line between doing that and walking into the cafe and throwing some garbage.
We submit that the acts prescribed by Section 4 of the Protection from Protesters Act involve trespass to land, and that those particular acts would involve not be protected by the implied freedom, Your Honour.
Well, what about Levy's case itself? Was that on private property or was that on public land?
Your Honour, we submit that there is no difference with the doctrine of trespass between private property and public land when considering its application to the implied freedom. Specifically, in Levy and Victoria, protests inside a prohibited hunting area were not protected by the implied freedom by virtue of the fact that neither the common law nor Victorian state law gave the protesters any right to enter the property at hunting times. Analogously, Section 4 of the Protection from Protesters Act gives protesters no right to hinder, prevent, or obstruct business activity on business premises, as such activities would be considered trespass to land. The expansive doctrine of trespass and limited doctrine of the implied license was affirmed by Justices Mason, Brennan, Dean, and Dawson of the High Court in Barker and Queen. The concept of trespass specifically, as invalidating the invocation of the implied freedom, was explicitly considered by Justice Callanan in Mulholland at page 298 and Justice McHugh in Levy at page 595. Notably, Justice McHugh opined that protesters have no right to complain about an interference, that they have no interference with what they have no right to do anyway. And he said, His Honour said that this is especially true in cases of trespass.
How do you deal with your opponent's analogy of the person who enters business premises for the purpose of making a complaint? To go to the complaints department and make a complaint. That person might be obstructing or hindering the business activity and is protesting, but yet, would the Act apply to such a person? Could it validly apply to such a person?
Your Honor, we submit that the Act would not validly apply to such a person if the way he is communicating to the business owner constitutes a high degree of interference with the business. There are two relevant considerations here. Firstly, the scope of the implied license, and secondly, the ambit of things that are prescribed by Section 4 of the Act. We submit that the scope is limited and the ambit and threshold of Section 4 is high. As noted by Justices Brennan and Dean at page 364 of Barker and the Queen, the scope of the implied license is dependent on the circumstances.
Do you agree with Ms. Bunting's submission that there is in effect a spectrum starting on one end from the word prevents and on the other end ending with the word hindered?
Yes, Your Honor. We agree that the words prevent, hinder, and obstruct do involve a spectrum. However, we contend our learned friend's submission that the principle of legality in reading down the provision is limited only to things that do not consider a spectrum, but different activities.
So you say you would disagree that the person that goes into the coffee shop and complains loudly about non-free trade coffee or whatever falls within this provision?
We would submit that a person who goes into a coffee shop and complains about that would not infringe the provision. As
Why
firstly,
is that person not hindering the operation of the business activity?
to this end, we must consider the meaning of the words prevent, hinder, and obstruct as qualified by the principle of legality, as noted at page 148 of Reginald Bell, to connote a high degree of interference. Prevent, as our learned friends have submitted, means stop from occurring, which is a complete stop. Obstruct means to block or make difficult a passage, which in business premises connotes a physical obstruction. The word hinder means prevent, interrupt, or retard in accordance with the Macquarie Dictionary. And we submit that reading this word in light of its context means that it does not include the complete prevention, and it does not include physical obstruction, but it does include an effective obstruction or effective prevention of business activity.
Did you say it does not include complete prevention?
The word hinder does not include complete prevention, Your Honor.
But it would hinder a business to discourage customers from attending for some political reason. For example, free trade coffee.
Yes, Your Honor, we submit that in some circumstances, where the hindrance involves a high degree of hindrance, then indeed it would infringe the provision under Section 4. However, due to a principle of legality, this high degree is a necessary qualification to a reading of hinder. And as such, His Honour's example of someone spilling coffee on the ground would not connote an interference with business activity under Section 4.
So you say it's only protests where there are large number of people that leave in the coffee example, or some sort of manifest effect on the business activity that is caught within this provision. Is that right?
Yes, Your Honor. We submit that the high degree of interference can be connoted by, for example, as you mentioned, a large number of people leaving, or, for example, if it goes over a long time, interfering with the business, or, for example, if the actual protest activity causes business activity to be completely stopped or hindered on the premises.
What do you say about the fact that the provision prevents the carrying out or deals with a business activity as distinct from the business activity? So, for example, if one protests about blue ties in McDonald's, that may hinder the sale of blue ties on that business premises, but does not hinder the business of McDonald's.
Yes, Your Honor. If it's a sufficiently high interference with either the sale of blue ties or the operation of McDonald's.
Well, no, let's ignore McDonald's. The protest is on McDonald's about blue ties. Doesn't that mean that the sale of blue ties, which would be a business activity, would be in some way hindered, and therefore Section 4 would bite?
Yes, only if the hindering is of a high degree, Your Honor.
It would have to be on the premises, though. The business of selling blue ties, presumably in that example, wouldn't be on the premises.
His Honour mentioned that the blue ties were sold in McDonald's, and in that case it would be on.
wish my wife had let me leave the Collingwood realm, even though we lost. Thank you.
Further, Your Honour, the concept of fundamental rights in reading down the provision in the principle of legality includes the implied freedom of political communication, as held by their Honours Justices Crennan, Kiefel and Bell at paragraph 331 of Moot and Queen.
Did the other judges agree with that?
Your Honour, the other judges, in considering the reading down of the provision, still found otherwise, that the provision could not be reasonably and appropriately adapted. However, in this case, we submit that the maximum 5-year imprisonment cannot be separated from the words prevents, hinders, and obstructs, as the provision must be read as a whole. Such a punishment for a contravention of Section 4 is additional support for a narrow interpretation, as imprisonment involves an abrogation of fundamental freedoms. It follows that because of this narrow interpretation of Section 4, with the limited scope of implied license, the implied license granted on business premises does not extend to the acts prescribed by Section 4. As such, there is no pre-existing right to enter a business premises and do the activities as prescribed, and therefore the invocation of the implied freedom fails, Your Honour. Our learned friends, at paragraph 7.1 of their written submission, at pages relied on Halliday and Neville at pages 7 to 8 in support of the proposition that there is an implied license to enter business premises and conduct protests as prescribed under Section 4. However, in noting this, in Halliday and Neville, Chief Justice Gibbs, Justices Mason, Wilson, and Dean added a critical qualification at page 7, and I quote, "An implied license will be implied unless there is something additional in the objective facts which is capable of founding a conclusion that any such implied or tacit license was negated or revoked." We submit that an implied license would not be implied in cases prescribed by Section 8, as it would firstly be revoked by the business owner, as no business owner would consent to such a high degree of interference. And secondly, even if there was such a consent to interference, then such activity would then not relevantly hinder businesses. Further, Your Honours, in resisting the invocation of the implied freedom in circumstances of trespass to land, the importance of this pre-existing right was, especially in light of pre-existing prescription, was underscored by His Honour Justice Keane at paragraph 234 of Tajor in New South Wales. Justice Keane noted that to accept that an activity otherwise prescribed by the law is excused by the possibility that the prescribed activity may also be accompanied by a communication on political and government matters would be to expand the scope of the implied freedom in an unprecedented fashion, especially in the current case where there is civil and criminal prescription of trespass to land. We submit that the implied freedom does not apply based on the rules in Mulholland.
Mulholland really had nothing to do with trespass. It was about whether the DLP should still be a registered political party despite the fact that it didn't have 500 members, which I see it's dropped below again in recent years.
Yes, Your Honour. However, Mulholland, with a majority of 5-1 on this particular point,
Yes.
considered whether there needed to be a pre-existing general law right,
Yes.
regardless of whether it whether there is a prescription on trespass or not.
Yes.
In that case, there was no pre-existing general law right conferred under general law or statute for there to be names printed on the ballot.
Yes.
However,
That was
the
because of Mr. Bennett's very persuasive advocacy.
Yes, Your Honour. However, the concept of trespass was explicitly mentioned in page 298 of Mulholland by Justice Callanan as invalidating the invocation of the implied freedom, and Justice McHugh in Levy at page 595. We submit that the doctrine of trespass is similarly applicable here, and Mulholland is still good law. The cases of Monis and the Queen...
I'm not going to argue with you about that.
Yes, Your Honour. As such, in the current case, where it is contentious whether there is a right prior to the invocation of the implied freedom, we submit that Mulholland is especially applicable, and therefore there has been no effective burden on political communication. In conclusion, the Protection from Protesters Act does not effectively burden the implied freedom of political communication in its terms, operation, or effect. This is firstly because the implied freedom does not extend to acts which a person does not have any right to conduct in the first place, and this is particularly evident in circumstances of trespass to land. Secondly, the scope of implied license does not extend to activities prescribed by Section 4 of the Act, due to a narrow interpretation necessitated by the principle of legality and ordinary statutory construction. As such, the first limb of the test in Mongi has not been satisfied. Unless your honours have any further questions, that concludes my submissions.
Yes, thank you, Mr. Sir.
May it please the Court, in addressing the second question, I will make two submissions corresponding to the two parts of the Mongi test. First, Section 4 serves a legitimate end compatible with representative and responsible government because the end it serves is to protect businesses' interests and not to regulate protesting. Second, Section 4 is reasonably appropriate and adapted to serve this legitimate end as it goes no further than is reasonably necessary, and there are no equally practicable alternatives identified by our learned friends. Addressing the first submission, our learned friends and ourselves are in agreement that one legitimate end of Section 4 is the protection of private business rights, as they stated, or the protection of business interests, as we stated at paragraph 2A of our written submissions. Therefore, these oral submissions are directed to the second end suggested by our learned friends at paragraph 16.2 of their written submissions and in oral submissions, which is that Section 4 is directed to the regulation of protesting. In brief, our submission is that the end of Section 4, when ascertained through ordinary principles of statutory construction, and in particular the principle of legality, is to protect businesses' interests or rights, which is a legitimate end and is not to regulate protesting.
Your problem, though, is, isn't it, that the statute the provision is only concerned with protesting. It's not concerned with activities for a purpose other than protesting, which normally would be a political protest. So, if the person just dumps food on the floor of the cafe because the person is an untidy person or is aggressive generally, that's not covered by this legislation. It's both the width and the narrowness which give you the problem, isn't it? The prohibited act is the act of protesting in certain circumstances.
Your Honour, our submission to that end is that protesting is specifically directed to by this Act because other general law measures have failed to address the problem of protesting adequately. For example, in New South Wales, protesters entered a New South Wales mine and cut the wires connected to 187 explosive devices, leading to the New South Wales Mineral Council asking for provisions similar to Section 4 to address the problem of protesting. So our submission is that this is why Section 4 targets conducting a protest as opposed to other hindrance of business activities. As a preliminary matter, what can be used to construe the end of Section 4 must be determined.
That, of course, is clearly a case where the person A has no right to be there and B is committing a criminal offence once there, independently of this provision.
Yes, Your Honour. However, these provisions have not adequately addressed the issue of protesting, as these provisions were in place when this protest took place on the New South Wales mines. So as such, we submit that Section 4 and being directed to conducting a protest was necessary.
You don't suggest, do you, that the cutting of wires in a mine is something that wouldn't be caught by the general law, quite independently of this provision?
No, Your Honour, that is not our submission. Our submission is that general law measures have failed to address the issue of protesting, and that this is why Section 4 targets conducting a protest. As a preliminary matter, what can be used to construe the end of Section 4 must be determined. Our learned friends use the short title of the Act, at paragraph 16.2 of their written submissions and in oral submissions, to construe the purpose of Section 4. We submit that this is not a legitimate way to construe the purpose of Section 4. The authority they cited, Northern Territory Planning Authority and Murray Meets at page 8, does not support this contention that the short title of the Act is a valid means to construe its end. Nor is the heading of the provision, and therefore the only reference to protesting that can be used to construe the end of Section 4 is conducting a protest on business premises where it prevents, hinders or obstructs business activities on the business premises. So therefore, it is apparent that Section 4 is directed to the protection of the carrying out of business activities rather than the regulation of protests. Furthermore, as per my learned senior submissions, the principle of legality gives a narrow reading to the terms prevent, hinder or obstruct, and the 5-year sentence, the words prevent, hinder or obstruct cannot be divorced from the 5-year sentence that Section 4 provides, which requires a narrow reading, as stated by their Honours Justices Crennan, Keithel and Bell in Monis against the Queen, at paragraph 331. My learned senior gave a definition of the words obstruct, hinder and prevent, so I will be brief on this. Our submission, however, is that the word hinder must be construed in light of the term prevent and to obstruct, which both entail a complete stopping of the carrying out of business activities, and as such, hinder is a high threshold, particularly when combined with the principle of legality and when read in light of the 5-year maximum penalty and $10,000 fine. Thus, our learned friend's submission in oral submissions and at paragraph 17 to 18 of their written submissions that states that Section 4 enacts a strict regulation of protesting is not the case. We therefore submit that Section 4 is directed to a legitimate end, and this end is the regulation of business activities rather than the regulation of protests.
Don't you still run into the point that Justice Bennett raised, which is in effect the person must not conduct a protest as distinct from a whatever else on business premises?
Your Honour, we submit that this is not a problem because conducting a protest is only prohibited by Section 4 when it prevents, hinders or obstructs business activities to such a high degree that they are completely prevented from being carried out, completely obstructed from being carried out, or so hindered that in effect no business activities are undertaken whatsoever.
So your case is in effect resting on the premise rather that the words prevent, hinders or obstructs are given a very narrow meaning.
Yes, Your Honour.
What is the difference between the words in your submission, prevents, hinders and obstructs?
Your Honour, we agree with our learned friend's contention that the word prevent means to keep from occurring. The word obstruct is defined by the Macquarie Dictionary as to block or close up, or by the Oxford Dictionary as to place or be an obstacle in. So this entails a physical obstruction on the business premises and differs from the prevention of business activity from occurring.
So there wouldn't be an offence under this Act if, for example, a patron in a cafe calls the waiter over to complain about the quality of the food. That wouldn't be caught, you say, by this?
No, Your Honour, that would not be caught by this provision.
What if the owner said, I completely agree with your protest, this is a lousy state government, unfortunately I have to conduct this business, give me a hand to clean it up?
Your Honour, I'm not sure I understand that question.
Well, what happens if there's no particular problem with the action by the proprietor?
Well, Your Honour, in that case, the business owner may well be using his business and therefore a business activity to advance the purpose of the political position, and as such, this would not be caught by Section 4 because it would not be a hindrance of the business activities.
No, but it may be a hindrance of a business activity as distinct from the business activity that's being conducted on the premises, which is this point about McDonald's and the blue ties. So the idea that the McDonald's proprietor may say, yes, you know, McDonald's is a harder example, but yes, the burgers in this place are rubbish. Or yes, I think blue ties are rubbish. That doesn't infringe upon McDonald's ability to conduct a business activity on its premises, but it does infringe upon the other person's ability, the blue tie person, from conducting a business activity on the premises. Wouldn't that be caught by your act? By the act, rather?
No, Your Honour. Section 4 is only directed to a provision, to conducting a protest where it prevents, hinders or obstructs the business activity on the business premises.
Yes, so the blue tie business is also on that particular business. It's not the business activity, so it's not the McDonald's. It's not the McDonald's and the McDonald's premises, it's like the Ray-Ban sunglasses, if you will, on the McDonald's, the side cafe or the side whatever. That business activity is being disrupted. That's still caught by this act, isn't it?
Well, yes, Your Honour, but it would have to be prevented, hindered or obstructed to a very high degree to be covered by Section 4.
So your answer, in effect, to the alleged unconstitutional nature of this act is we read it to mean unreasonably prevents or unreasonably hinders or completely obstructs the carrying out, Is that right?
No, Your Honour. We read the words prevent, hinder or obstruct to entail a high degree, and this was the approach of His Honour Justice Gibbs in Regina and Bell, and the approach of their Honours Justices Crennan, Keithel and Bell in Monis Against the Queen at paragraph 336, where they read the word offensive to mean offensive to a high degree, though not necessarily the most extreme.
What if, presumably what this was really intended to get at, there was a protester in the Tasmanian State Forest that was stuck up on the top of the tree, but only preventing logging in a very small area. Would that protester offend this section?
Your Honour, that protester would still be preventing, the hindering or obstructing the carrying out of the activity of logging, even if it is in that small area. However, they must do so to a high degree, and being stuck up in a tree, preventing logging from being undertaken in that area is a high degree.
I mean, even if it wasn't being conducted in the area at the time, but they were still in the general area of where logging was proposed to be built. I mean, what we're getting at there are often questions of degree. It'd be handy if we had in this material the second reading speech.
Yes, Your Honour. One example that we would submit is that one person in a moderately sized clothing store protesting against the unequal distribution of wealth, banging on a drum extremely loudly and shouting constantly for several hours may be the low threshold of a high degree of hindrance.
It's like someone outside my hotel room in San Francisco one night screaming, "Jesus, save me."
That may be a hindrance, but it is not necessarily a protest.
That's right. I told you I shouldn't feel out. You're safe, I'm Catholic. Probably not appropriate these days.
Perhaps not, Your Honour. Addressing the second submission, Section 4 is not reasonably appropriate and adapted. Rather, Your Honours, Section 4 is reasonably appropriate and adapted to serve its legitimate end of protecting business rights. Our submission, in brief, is that Section 4 does not unduly burden the implied freedom when construed narrowly as required by the principle of legality, and Section 4 is reasonably necessary as our learned friends did not identify any other equally practicable, less burdensome alternatives. In Levi and Victoria, at page 614, their Honours Justices Toohey and Gummo held that the law was reasonably appropriate and adapted because it went no further than was reasonably necessary to promote its legitimate ends. Section 4 goes no further than is reasonably necessary to promote its legitimate ends. It only prescribes conducting a protest on business premises if it prevents, hinders or obstructs the carrying out of a business activity on those business premises, and this, as we submitted, requires a high degree of hindrance, prevention or obstruction so it does not necessarily catch all protests. In fact, it only catches a small proportion of protests. Section 4 is...
It could capture a very small activity. Suppose you have someone with a little coffee cart that is being taken round to different business premises, and the protester stands in front of it on one business premise and says, "This is not free trade coffee, don't buy it." Now, that would clearly be caught, although it's not the primary business activity on the premises.
It still allows a large proportion of protest activity to be conducted. Section 4 is analogous with the impugned provision in Levi and Victoria. In that case, the provision was held to be reasonably appropriate and adapted to serve its end of protecting the public interest and personal safety, because it only affected unlicensed persons entering hunting areas during hunting times. Section 4 is reasonably appropriate and adapted to serve its end, as it only applies to business premises during times when business activities are being carried out on the business premises. Furthermore, as we have submitted, it requires a high degree of prevention, hindrance, or obstruction. Therefore, Section 4 does not have the expansive interpretation that our learned friends have suggested.
Do you say anything to the proposition that was raised by Ms. Bunting that the Tasmanian legislature could have imposed a lower fine or a lower term of imprisonment? Or do you say that's just completely irrelevant?
Your Honour, our submission is that this is not an equally practical means of serving the end of protecting business interests. This is because deterrence is necessary. We earlier gave the example of the protesters entering the New South Wales mines and cutting the wires connected to 187 explosive devices.
Sorry, can I just say that means you accept that the quantum of the fine or the duration of the imprisonment or potential imprisonment is a relevant consideration in determining whether there are other reasonably appropriate or applicable measures?
Your Honour, we are not aware of authorities that have used this approach, but we also have no authorities that have rejected this approach.
Monis did, all the judges in Monis referred to the fact that there was a high penalty and used that to justify saying that the conduct had to be significantly offensive and using different forms of words. But certainly the penalty was regarded as relevant there.
Well, yes, Your Honour, our submission is that the penalty is relevant to giving operation to the principle of legality and attracting its operation, and the penalty may well be relevant to whether this legislation is proportionate. Our submission is that the 5-year maximum penalty is proportionate, because when considered in light of the example of protesters cutting the wires to 187 explosive devices, 5 years does not seem disproportionate to the gravity of the offence. Furthermore, deterrence is necessary, and this was
So
held...
you consider the worst possible example and judge proportionality by that? Is that the appropriate way to construe Monis?
Your Honour, our submission is not that the lower end of... Our submission is not that the 5-year maximum penalty should not be considered, but that it is not disproportionate. This is because deterrence is necessary, and this was held by the Honours Justices Crennan, Kiefel and Bell in Monis against the Queen at paragraph 324, where they noted that the impugned provision in question was intended to deter offenders as well as to punish. And deterrence is necessary. In another example, protesters completely prevented the carrying out of logging as a business activity in Butler's Gorge in Tasmania in February 2013, and other general law offences and existing criminal sanctions have not adequately addressed this problem.
I suppose you would say that the fact that many protesters are passionately devoted to their causes means that you need a higher deterrent to deter them.
Yes, Your Honour. Our learned friend's submission that distinguishing between political and non-political protests would be equally practicable must also be resisted, As they noted, there has been increasing privatisation of government services, and the High Court, in a unanimous judgment in Longy and A Australian Broadcasting Corporation, at page 561, noted that statutory authorities and public utilities are part of the executive. If I may have 2 more minutes just to summarise this submission.
Yes, you may.
So because such a significant proportion of businesses statutory authorities carry out business activities, and these must be protected, like any private business, and private businesses may carry out public utilities. So because of this, excluding political protests from the ambit of Section 4 is not equally practicable, as it does not serve the end. At paragraph 125 of Tajor in New South Wales, the Honours Justices Crennan, Kiefel and Bell held that the legislation was reasonably appropriate and adapted, as the appellants in that case had failed to identify any alternatives. In this case, we submit that our learned friends have also not identified any equally practicable, less burdensome alternatives to Section 4, and as such, Section 4 is reasonably appropriate and adapted to serve its legitimate ends.
Thank you.
Unless your Honours have any further questions, that concludes our submissions.
Thank you very much.
May it please the Court.